Copyright disclaimer. Under Title 17 U.S.C. Section 107, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing. Non-profit, educational, or personal use tips the balance in favor of fair use. Okay, Supreme Court allows Scientology lawsuit to proceed in civil court rather than religious arbitration, dated April 20th, 2022, by David Ettinger. The Supreme Court today denied review in Bixler v. Superior Court, where an unpublished opinion of the 2nd District Division 5 Court of Appeal overturned a Superior Court order compelling arbitration of a lawsuit against the Church of Scientology. The lawsuit alleges that former church members, after reporting they had been AR'd by a church member, were subjected to extreme retaliation encouraged by the church. The former members had agreed in writing to pursue claims against the church solely and exclusively through Scientology's internal ethics, justice, and binding religious arbitration procedures. One former member signed an agreement with slightly different language. The Court of Appeal held that the Church's First Amendment right to resolve disputes with its members without court intervention yield to the former member's First Amendment right to leave the faith because the dispute was one which arose after petitioners left the faith and which can be resolved on neutral principles of tort law. One justice concurred only in part, but without writing a separate opinion. Division 5 had previously summarily denied the plaintiff's writ petition by a 2-1 vote, but the Supreme Court granted review and sent the case back with directions to decide the merits. The Supreme Court also today denied a request to publish the Court of Appeal's opinion, while the Court of Appeal's decision not to publish its opinion is surprising. Given the legal issues involved, the Supreme Court's refusal to order publication is not. To our knowledge, the Supreme Court has never ordered an opinion published after the authoring Court of Appeal has recommended against it, as Division 5 did here. So that's it for that article. I believe that's some type of a precedent that SA abuse survivors don't have to go back to their abusers to beg for arbitration. Have a good day or a good night wherever you are. I will put the link in the description. Peace.